has been raised today is questioning the stage at which the 10 marks allocated for prior teaching experience is to be awarded. Stop. Whether the same is to be awarded prior to preparation of the interview list
Preliminary interview.
or prior to the preparation of the merit list.
And some benefit has been given. The benefit is to be restored. If a contract becomes void, benefit received already restored. I'm not going to principle, I don't argue. I said this argument not open for my learned friend to argue in High Court to invite stricture from Supreme Court.
All right.
When Supreme Court has actually given the benefit to them. And whether under this benefit you are appearing in the next election days. Now, next point is that at what stage?
Yes.
Mark. My Lord, I humble submission is this. If my Lord attention been drawn to definition clause, is it?
Yes.
My Lord attention been drawn to definition clause and the schedule,
Yes.
not to substantive part of the rules.
All right.
Not to substantive part of the rules. But in case of any ambiguity in the rules, substantive part has to be seen.
Yes, please show
And
me.
that's can you see rule 11? Or can you before that some other rule? Yes. Yes. After the definition clause ends, then we not kindly see other clause, duty, etc. omitting advertisement issued. Then we not kindly read 9. This substantive part of the rule. Form of application. The form of application for appointment shall be such as may be determined by the Central Commission from time to time. And the mode of submission of such form shall be exclusively online. The form of application given. Pro forma of the application shall be published Central Commission website. It has been published, not placed before the court. Here now there's specific clause regarding teaching experience. That is not placed. That has been suppressed. Now fees, etc. Lakshmi has to see the form. I shall show you the form. See the form. Come to see the form. I'll show the form. We have a specific space. They say, are you working as an assistant teacher in any government school? Yeah, I don't. There's a question is there.
That is the issue. Why government school and not a private school?
Correct. That issue is being raised when they knowingly appeared in the examination under the rules and filled up the forms. At that time, they did not say, why are you asking me at this experience? Whether this is a malafide application and come to that later on. This experience counts is also a form. Now, let's kindly see now, next substantive part. Then I'm omitting submission 10. This is method of SLSC and for selection of candidates and preparation of panel. I'm now assuming the rule is valid as Madam said. Then only this question arises. Under the rules, what is provided is to be seen by law. That they say, according to their interpretation, this mark for the teacher experience should be given at the time of publication of merit list. And another view, and Mr. Thor has applicable also, that 10 marks will be given at the time of publication of interview list. Now, interview list has been published or is to be published today. Whatever may be, it is ready. Now, we do not know whether the party who have examined, etc., they have given the 10 marks
or not.
Now, if they have given, then the question of objection arises. I think if they know it has been given, then they have to argue this. Number then what the court normally does, if a body, when the two interpretations are possible, they are assuming they are possible, which is not, I will show you also not. Even if possible, the interpretation or the view taken of the rules by the authority, if it is not totally irrational, that has to be accepted by the court.
Yes.
So they have not argued that this reading of the rule and giving the marks, etc., make it that the interpretation cannot be made by anybody, no reasonable person. Now, Therefore, the approach is wrong.
All right.
Giving their views only is not enough. They have to say the other view is preposterous. No reasonable man can take in that view. That argument not made. That is a basic principle. Now let's see whether the argument has not been made and rightly not made because rule expressly provides that the mark should be given when.
All right.
Now let's see minute 11 is the method of this substantive part. Nobody can depart from this. Method of SLC selection of candidate preparation fraud. Preparation of panel. Once application submitted, Rule 10, Central Committee shall proper secure it. I'm omitting that. 2. This 2 is important. Central Commission, after receiving application form, shall prepare a list of candidates for the purpose of database preparation of the preparation of data. My lord, copy is clear. My lord, copy
Yes,
is clear.
yes.
Clear. My copy. Preparation of database after making preliminary scrutiny of age and qualification of the candidates, which make them eligible to appear in the OMR and base test. The first list we published for who can appear in a written test. The first list. That is on the basis of age and scrutiny of the applications. Now, let's see when the second is coming into place. Just stages. First is for written test. Now let's come. Then what happens next stage? Then appoint etc. Auditor, the appoint moderator, the appointed professor, etc. Scrutiny, etc. Then not come to Roman 5 V. Central Commission shall publish in its official website preliminary model answer keys after written test and may invite suggestions and the objections from the applicants. So after appearing a written test, this is very peculiar rule. After appearing in the written test, the examinees would know whether their answer is correct or not. Model answer is coming, it has come within 7 days in this case. So when all these applicants are made, they know whether their written test is likely to succeed or not. Their model answers are there. Final model answer has to be prepared, given. Then objections are invited to the model answers. Objections are similar, shall be provided. Central Commission shall publish a preliminary model answer keys after within of written test and may invite suggestion, objection, etc. Then, provided the suggestion, objection must be submitted within 5 days after publication of such model answer keys and should be supported by at least 2 authentic academic publications. The Central Commission shall form a subject-wise expert committee comprising not less than 2 members of the rank, not lower than professor of college, university. Expert committee shall deal with the suggestions, objections, if any, received from any applicant. The decision of the committee shall be accepted by the Central Commission and shall be binding. Expert committee binding. So what is the model answers will be finally settled by expert committee. And that will be published. There is no mention in the writ petition that model answers have been published, have been given, and final model answers have also been published when. And they know what are the correct answers, this petitioner, and they can compare with their answers. And obviously, similar, they have found that their answers not correct. Their chance of likelihood of getting through the written test is remote.
Is there any cutoff marks?
Yes,
you have to get something in the written examination.
Coming to cutoff mark is later on coming to. Therefore, my point is, these petitioners have suppressed the fact when the model answer knows, I am instructed within 7 days from written test. I've given also in a list of dates, written test on 14th September or something, for different classes, different subjects. So long before filing of the application, they knew whether their answers were as per the model answers and what was the chance of success. And it's obvious they realize the chance of success is remote because the answers, they now come with the application. And move the application when? Now, when I'm pausing here. See the next stage. Next stage. Central Commission shall finalize the upload 7 million. Central Commission final upload on your website final model answers keyboard. This has been done. Final answer, which is binding on everybody. They can compare with theirs. Then age is very important. Thereafter, what happens? Central Commission shall prepare and publish in its website preliminary list with details of the candidates to be called for interview is subject to verification of credentials and eligibility. Then category-wise, and on what basis? On the basis of preliminary merit score as defined in Rule 1K in the ratio of 1.6 into 1 for final vacancies. And that is 1.6 times here. Therefore, not this final the list for interview, which is due to be published today, I'm told, everybody is saying so, that must be prepared on the basis of preliminary merit score as defined in Rule 1K. Now see Rule 1K? It's Rule 1K. It doesn't mention Rule 1F or L, 1K. Not L. Interview list in respect of SL charitable, etc. means in case of vacancies in the post of assistant teacher, a list of candidates prepared by Central Commission to be called on merit for oral interview and lecture demonstration category-wise on the basis of preliminary merit score, that is, some from written test and the TET for upper primary and academic score in the ratio of 1, etc. What is academic score? Now see, definition of academic score. Schedule. Yeah, see, but we're talking about academic score. 36. Page. What page exactly? I'm not able. That's it's one million now for you. Academic score. Academic scores. The Schedule 2A. Schedule 2A. Selection 9 and 10 shall be made on the basis of marks obtained in the written examination, educational qualification, prior teaching experience, oral interview, lecture demonstration, determined by Central Commission in the following manner. That's the select sequence. That when the merit list comes, everything will consider how much it scored in them. Now the sequence of events is mentioned here. Now you see academics. A written examination, 60 marks. First one. Academics has got two parts. Educational qualification, 10 marks. Similar based on what? Based on marks, graduation and post-graduation in subject for which applied, whichever is higher, according to the following formula. Similar is also 60%, 10 marks, below. Nobody objected to this. Nobody objected to this. Why you different? Why 60% will get 10 marks? How is it relevant at the time of teaching? Nobody has said so. Number 6. No rounding allowed. Then B. Prior teaching experience, 10 marks. There also it is stated 2 marks for each year of service. So maximum 10 marks can be given, provided there is 5 years of teaching experience. Now, teaching experience, appointments are being made for government schools, government-sponsored schools. And everybody knows, government schools, mode of education is different from private schools. They are not same. Lama tenure, St. Xavier's mode of teaching is not same as the government school. So they are asking for teacher of government schools and asking for teaching experience of government school teachers. Number of teachers, can anybody said that the teaching experience in government sponsored school, etc., is not a matter of weightage in case of appointment in government schools. It is not a case of appointment in private schools that we are asking for your teaching experience in government schools. Then that could have been not relevant. Now, therefore, but I am first on sequence. Sequence part, prior teaching experience, 10 marks to be given after secondary. Then that is to be given before oral interview. So that is to be given before the final list of oral interview is published.
That means at the time of declaration of this
Yes.
2K, that is the interview list,
Yes.
the 10 marks is to be added.
Then on the basis of that, the final list of persons who are to be called for interview will be published.
Yes.
Which is supposed to be due to be published today.
All right.
Now, if the examiner or the authority has proceeded on the basis, just 10 marks is to be given at this stage to before publication, for preparation of final list of interview. Can that said to be irrational? That's the question. Now, this is rule clearly provides. First thing I submit, my lord, is most unfortunate, if I have submission, that definition has been shown, schedule has been shown, but substantive part of the rule 11 has not been placed, your lords. And that clearly says when this marks are to be given for teaching. Namely, I go back to the substantive part of the rules. Clearly showing me that it should be done. Let me not see me not. Hey, this is not. Have you late I was reading?
Yes.
I read once more to say this is a
Yes.
If can it permit me to read just once more that I allow this repetition. Is for the Central Commission shall prepare and publish in its website a preliminary list with details of candidates to be called for interview, subject to the verification of credentials and eligibility. Category-wise, the list should be category-wise, and on the basis of what? On the basis of preliminary merit score as defined in 21K. Defined in 21K, not 21L. So, my lord, in my hamlet, it's very clear. Hands of the examiner are tired by the rules. They have to, as per the reading, they have to take into account the teaching experience marks, if available, to any students at the time of preparation of interview list. There's a second list to be published. First, written test list, now second interview list. Second, a further list to be published. Thereafter, he may not want to know. He will not kindly come to the list is finally published on website, then kindly come to me not 9. That's not the end of, that's not final, not end of the matter. To prepare the preliminary list as referred to above, marks obtained by the candidates who have secured test position on the basis of ratio, etc., shall be the cutoff marks. Was cutting marks. The lowest mark is obtained, that will cutoff marks for the particular category. If, however, said cutoff mark is obtained by more than one candidate, all such candidates who have obtained the said cutoff mark shall be called for interview. This is the further scrutiny. Then, my lord, unless a candidate secures the cutoff mark in the particular category, he shall not be considered for that particular category in any subsequent stage of selection for that category, irrespective of his merit score obtained after interview in any other category.